What's up, everybody? Welcome back into another episode of The Lawyer You Know. And we are going to be breaking down as many of these Karen Read documents as we possibly can. It is heating up as we get close to trial. You guys have learned by now in the cases we've covered, this is when it all happens. There seems to be lulls and delays and slow periods as we wait and wait and wait for it to get on the eve of trial. We're less than 2 months away, and some very serious motions and documents have been filed. And today we are at least going to get to the defense's motion to strike the Commonwealth's dog bite expert and the motion. Which one are we going to do? The motion to compel. I think we're going to do the motion to compel, which talks about the Sandra Birchmore documents and why would the defense want that, among other things. And do we think they're going to get it? We will see if we can get to anything else, or if you guys want to, let me know in the comment section and we can do a part 2 with more documents that have been dumped on us here and will continue to happen as we get closer and closer to trial number 2. So we are starting out with the motion to exclude the dog bite expert, James Crosby. Okay. And we'll make sure we point out the fact that he is a PhD. He will be called Dr. Crosby throughout this document. But don't get it twisted. He is not a medical doctor, which is going to be a big topic of conversation throughout this motion. And when Dr. Russell, the defense's dog bite expert, who is a medical doctor, when she was being voir dired, when the Commonwealth was trying to strike her, saying she did not have the proper experience or education, was not qualified to give this opinion, and her methodology was lacking or did not rise to the level of the Daubert standard, I knew that one day in the not so distant future, we would be having a motion like this, because it was very clear the Commonwealth had secured their own expert. And it was very clear to me once we went through Dr. Russell's testimony and once we listened to what Dr. Russell had to say, it was clear to me that she was about as qualified as you could possibly get for what we're trying to do here, right? Was this a dog bite? What were these injuries from? Was it a car accident? What caused the injuries on John O'Keefe's arm and body? And as we listened to Dr. Russell testify, I knew that there was no way the Commonwealth was going to be able to find somebody that could really compete with Dr. Russell. So if they wanted to have their own expert, it was going to have to be something different, right? It was going to have to be something maybe a little bit outside the box, or something that they could compare to Dr. Russell and say, this is the type of expert it should be, not somebody like Dr. Russell. And that's what they have tried to do. Now, will their try be successful? I don't know. Let's take a listen to this document. Now comes the defendant, Karen Read, and respectfully moves the Honorable Court to exclude the testimony of James Crosby concerning the medical cause of the injuries to the right arm of the decedent, John O'Keefe. Exclusion of the testimony is compelled because it fails each of the 2 main prongs of the Daubert-Lanigan inquiry: qualifications and methodology. That is, Dr. Crosby is not qualified to render the opinions he proffers. It is undisputed that he is not a medical doctor. He thus fails per se the crucial qualification inquiry of the Daubert-Lanigan standard. This failure is not curable. In addition, the methodology that he invokes in his report is not reliable. Among other defects in his methodology, there is no showing that it is generally accepted in the relevant medical community, and the methodology is replete with errors, as is demonstrated in the affidavit of Marie Russell. So this brings up our first question here. Do you guys want the affidavit of Dr. Russell? Do you want me to read that in its entirety as well? If so, again, we got about an hour and 15 minutes here until my next appointment, so I will get to as much as I can. If you want me to read Dr. Russell's affidavit, hit that like button. If we get to 1,000 likes, I will read Dr. Russell's affidavit after we get through this document. It's submitted as part of this motion. The failure of either Daubert-Lanigan prong requires exclusion of the proffered testimony. Dr. Crosby fails both prongs. And now we get to the argument, which is what lawyers are good at. The Commonwealth fails to and cannot meet its burden to establish the requisite qualifications of Dr. Crosby. The crucial issue in Massachusetts for a Daubert-Lanigan inquiry is whether the proffered witness is qualified to give an expert opinion regarding the subject matter of his testimony. The subject matter of the testimony of Dr. Crosby, as described in his self-styled preliminary report dated January 24, 2025, is the medical cause of the injuries and wounds to the right arm of the decedent. So a couple things here that are just kind of foreshadowing. Number one, preliminary. When you get that word as a preliminary report as an expert, it's always frustrating because that would indicate that they can, in fact, change or amend or add to their expert opinion. Yet we are supposed to disclose that to each side. So when you put preliminary, it leaves it open, which is why when you take a deposition, you ask questions like, do you have any other opinions? Which the state in Sarah Boone's case acted like that was such a horrible and unfair question, but it's not, because we're lawyers. We're not experts in whatever the expertise is of the person that we're usually deposing. So we got to know, what else are you going to talk about at trial? Tell me everything so that if I have questions, I can ask you. And if I need to hire an expert to rebut anything you said, I have to know. And that's what they're trying to get at here with these quotations of preliminary. They are going to pick into a lot of things and say, he's not even sure. He hasn't even nailed down some of what he's going to testify to. And the Commonwealth will say, well, this is just his preliminary opinion, Judge. We wanted to see what objections they had. And now that we know their objections, we can fix his preliminary opinion with his final opinion. That's not how it's supposed to go. And when you have the deadline, and the cutoff to notify which side, my chair is like spinning out all over the place. When you have the deadline to notify the side who your expert is and what their opinion is going to be, that's their final opinion. You cannot add further opinions. Now you can say, oh, I clarified or whatever, but you can't add new opinions later past the deadline. So preliminary or not, they need to know his opinion, and it's going to be taken as his opinion at this point. Also, we've noticed multiple times they've said things like medical cause of the injuries, and they mentioned that he's not a medical doctor, which is per se means he can't testify under Daubert. Now, I would give a little bit of pushback. Usually Daubert doesn't have, you have to be a medical doctor to testify to X, Y, and Z, which is why it leaves it a little bit more vague, right? Do you have the education, experience, expertise in this area in order to assist the jury in a way that could make you an expert? The judge is the gatekeeper. It doesn't say doctor means yes, not a doctor means no. So when they say it's a per se strike, we're going to talk about why and who they cite and where they get that precedent, right? Why are they saying it's per se? Why are they saying you have to be a medical doctor in order to testify about these things? We're going to have a little clip to play you on who exactly said that. On June 18th, 2024, this court was clear and emphatic in its statement about the foundational qualifications a proffered witness in Massachusetts must possess before he or she can opine on the medical cause of an injury to a person. Such a person must be a medical doctor. Well, there you go. I thought it was a little further down in the motion. I guess not. Specifically, on that date, Your Honor ruled, Dr. Rentschler, though I have some concerns. Okay, so she said the one ARCA expert's fine, but this doctor I have some concerns. It's clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Only a medical doctor can do that. So I'm going to reverse ruling on the rest of his testimony. There are certain things he can testify to. I'll hear you again before he testifies next week. Let's just proceed with the trial today. And in case you forgot what that sounded like or looked like in living color, let's take a listen to it together. It's a quick clip here of her saying exactly that. And then I'm going to remind you of some of the context of this because it is interesting to talk about whether or not Dr. Rentschler should have been able to testify to any of this.
Testify to what his involvement. Dr. Rentschler, though, I have some concerns. It's clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Only an MD can do that. So I'm going to reserve ruling on the rest of his testimony. There are certain things he can testify, and I'll hear you again before he testifies next week. Let's just proceed with the trial today. So, okay, so those are my rulings. Are they clear?
So he's not a doctor, therefore he can't testify to the injuries. Now, I maybe it's a little bit different in Massachusetts. Usually Daubert is pretty much the same around the country. But I think there are some situations where non-medical doctors may be able to testify to certain injuries. And in one of those, if you remember back to when Dr. Rentschler was trying to testify about John O'Keefe's injuries, it wasn't that he was saying it is a dog bite or whatever. He is a person that deals in car accidents all the time. And he sees the types of injuries that car accidents leave. He knows how heavy and how big of an object a car is, how fast they're going, can do all the math and the calculations. And he can come out and say, this is not what it would look like. This is not what it would look like if you got hit by a car, that size car at that speed. I actually think there's a world in which he should be able to opine on that issue. Now, people can disagree with me, and that's fine. But if he's the expert and he knows the amount of mass it takes to break a bone, right? Or to cause a bruise or whatever, and he can do that math and he can compare it to the math of what the SUV was traveling and where it would have hit. In my opinion, that's an interesting opinion that I think could help a jury to exclude a car accident from causing those injuries. She didn't allow it. And she said specifically it was because he was not a medical doctor. That was the only reason she said on the record at that time. So if we're going to continue using that, and the defense has had a lot of rulings not go in their favor, so when they finally have one go their way, or I shouldn't even say, at that point in the trial, it wasn't going their way, but when they can use the judge's ruling against them for one witness, for them on another, they're going to do that. And that's why, again, we mentioned this multiple times when Dr. Russell was being voir dired, that she is a medical doctor. Who better to testify about this stuff than her? Nobody's going to be a specific dog bite expert where all they do is measure and focus their whole world on determining dog bites. That's not how it works to be an expert. It doesn't have to be your life, but your experience, your education, and what you have to do does have to specifically deal with that expertise, and hers did. Dealing with injuries, dealing with car accidents, dealing with dog bites, dealing with ER issues, traumatic injuries as a cop, reporting to car accidents, reporting to dog bites, an ME. She has all the experience you want. Ashley says, why does the court wait so close to trial for all these motions? Seems like it could be better organized, especially with this being a retrial. Ashley, you know what? If only everybody had your common sense, right? I say this in every case. I get annoyed in every case. Every time I have a mistrial or a case where we go to trial and we can't go because there's not enough judges, so we have to get it continued on the date of trial. And what do? They push back all the deadlines. And I'm like, Judge, can we please get all this stuff done now so that before trial, they're not saying, oh, we have to continue it because we have 3 depositions to be done. This is just how it is in the law. I don't know what else to say. They have deadlines, and to a lot of lawyers, deadlines means that's the day you should do it. Very rarely do you see lawyers, especially defense lawyers, do things prior to a deadline. We always try to do that because from our perspective, especially in contingency fee cases, there is no benefit for us to let a case last longer. To a lot of lawyers that are getting paid hourly, there is a benefit for a case to just drag on and last forever, and for trials to get continued and to have a trial 2 or 3 or 4 or 5, 6 different times because you get to keep billing and you make more money as the lawyer. And some judges are lazy. I'm not going to say all judges, but some judges are fine if you never go to trial, right? Because it's harder work for them sometimes when you go to trial. So it all depends, and you get the perfect storm, and it just takes forever. It shouldn't, but a lot of times it does. And a lot of times one side is really trying to push, but if the other side does nothing until the deadline, you have to respond and you go back and forth, and it creates these delays right before trial. Wafa said, love all the coverage, Peter. I'm hoping I don't get hate for this. I love the Karen Reed coverage, but would love to hear your input on the Madeline Soto case. A lot of evidence that the defense is disputing, and that trial is coming up. So if you guys are interested, I will cover that trial. Just let me know in the comment section. I did do a podcast on this. So if anybody wants to go and check it out, you can. I think it was one of the ones I did with Annie Elise. So go check out our podcast on it. We did do a deep dive on it. Azam, Peter, law enforcement and prosecution have all the power and they make the decisions, right? Yes. But if they have all the power, isn't it already being unfair to the defendants? Yes. That's why all of these laws are created, to try and make it a fair trial for the defendant. And that's why everything is so specific and everybody's so careful, because everybody knows it's not a fair trial for the defendant, right? If we're just being honest, laying all of our cards on the table here, we preach that so much as lawyers. We try to bang it into each other's head, like, make sure it's a fair trial. He is presumed innocent, or she is presumed innocent. Do not do anything to infringe on their constitutional rights. Everybody is reminded of that. All of the case law is there to protect it, because we know going into the process, when they're there in an orange jumpsuit and cuffs and everybody walks in, they assume they're guilty. That's how it is. So we try to level the playing field as much as we can in a trial. Tony said, question, can't an expert opinion change with the introduction of new evidence? Yes, but they have to disclose that expert opinion. And if it's past the date, it might be a new undisclosed expert opinion that isn't allowed or admissible to be testified to. So there are certain parameters in which you can do it, which you can't do it. You can't just necessarily change and be like, oh, I didn't know about this, especially if whoever hired you and whoever's agent you are. So the prosecution hired you and they already knew about that. And you're like, oh, I just found out about this. Well, it's like, you should have known. They should have provided you everything you needed. So it's not just like, oh, well, I want his opinion to change, so I held back this document. Now I'm giving him this document so he can change his opinion because we just saw a good motion to exclude him. So far, we are on page 2. We're not moving very quickly. I like to move quicker through these. Dr. Crosby fails this rule of law stated by Your Honor. This rule of law stated by Your Honor. His failure cannot be disputed. Also, I don't see any case law saying that it has to be a medical doctor. But I assume if it existed, the defense would have cited it. Dr. Crosby's report and his accompanying curriculum vitae clearly show that he is not a medical doctor. Rather, these documents demonstrate that he merely possesses a Master of Science degree from the College of Veterinary Medicine and a PhD in veterinary medicine science, or medical science, both from the University of Florida. Boo. Neither of these are or even come close to a Doctor of Medicine degree or being a licensed medical doctor, nor is he an odontologist or Doctor of Veterinary Medicine. Okay. A lot here to break down. We're not really going to get into, what degree is necessarily the best, but clearly very different things, clearly not the same thing. Will Judge Cannone stand by that ruling and say, not a medical doctor, going to strike him? And if she doesn't, the very first motion for the defense should be doctor, yes, doctor, not medical doctor, but still Dr. Rentschler should also be able to testify to John O'Keefe's injuries and the causation of those injuries, that it was not from a car or unlikely to have been from a car. And if she's going to let Crosby testify, she's almost got to let Rentschler testify too, I would assume. Then she'd be overruling herself again. Moreover, Dr. Crosby concedes in his report that he's not a medical doctor, stating, I am not a physician. Dr. Crosby then appears to express awareness of and sensitivity to this failure of qualifications. He unsuccessfully attempts to evade this shortcoming by raising a straw man argument that he should escape this failure because this case is not about the treatment of the wounds of the right arm of the decedent. There in his report, he states, I'm not a physician. I'm not licensed to treat injuries or illnesses in human patients. However, this case is not about the treatment of victim John O'Keefe's injuries or wounds. Thus, any opinion regarding the medical treatment of Mr. O'Keefe is inapplicable to the issue at hand, irrelevant, and has no impact on my opinions for the opinions or the opinions that have been asked of me in this case. So what does he do? He says, basically parrots what Hank Brennan and the prosecution team argued at the voir dire hearing. Yeah, she's a medical doctor. Yeah, Dr. Russell has treated a lot of patients. Yeah, she may have seen patients come in and she knows already that they were hit by a car and she treats them. That's why she's not diagnosing causation necessarily or trying to figure out what is the cause of this injury, because she already knows, because somebody tells her. It's very different. Treatment doesn't matter. And they take that, and Dr. Crosby tries to use that in explaining why it is not a big deal, NBD, that he is not a medical doctor. Now, the same could be said about Rentschler. Rentschler's not talking about treating those injuries, right? Rentschler wasn't talking about how you treat an injury from a car accident. He was going to testify that these were, I think, if my memory serves me correctly, I think that's what Rentschler was going to testify to, that it is unlikely that these injuries were caused by a car. People are asking, what is this guy's opinion? So we don't have his report, but if I were to kind of extrapolate based on what we're going to read in here, he is probably going to testify that those are not consistent with a dog or large animal, and they're definitely not Chloe, because he took some measurements of Chloe and it doesn't fit with her. Okay. Now, is he going to say they're from a car? Doubt it, but they'll probably have somebody else say that. The unilateral manufacturing of a treatment issue out of nowhere by Dr. Crosby is flummoxing and nonsensical. Well, I don't think it was created by Dr. Crosby. I think it was created by one Hank Brennan. First, the defense has never mentioned any treatment of the decedent. Defense witness Dr. Marie Russell rendered opinions about the medical cause of the wounds to the right arm of the decedent. This is where the defense starts to go, oh, what is this all about? We didn't say anything about treatment. But what's really happening is the Commonwealth is doing exactly what the defense said, and they're trying to lessen the blow of the fact that he's not a medical doctor, and they're trying to explain why that's no big deal that he's not a medical doctor. She did not render any opinion on treatment. Second, the fact that this case is not about treatment of the wounds to the right arm of Mr. O'Keefe cannot save Dr. Crosby from his lack of the requisite qualifications, nor can it be allowed to camouflage the fact that the import of Dr. Crosby's entire report is him opining on the medical cause of the wounds to the right arm of the decedent, something he legally cannot do in the Commonwealth of Massachusetts. In this regard, his report states, Dear Mr. Brennan, this letter is a preliminary response to your request for my professional expert opinion regarding the injuries and defects to the right arm of decedent John O'Keefe. Defect is a weird word. They're going to get into that later. But he does not say medical injuries. He just says injuries. And the defense keeps slipping in this word medical. Do you consider this a medical opinion? Are these medical injuries? Are injuries just injuries? Are some injuries medical injuries and other injuries not? Would you call any injuries chemical injuries or traumatic injuries versus chronic injuries or chronic pain? Is it medical pain? There's a way you can parse and use words however you want. Words are important. Definitions are important. Lawyers know how to use words in the way that is best for their client and the way that they see things. The way I look at this, the defense very intelligently used the judge's own words in a very similar analysis she had to do with the ARCA expert, and she has already made this decision. Therefore, why are we even here? But they don't stop there. They continue to hammer away at the rest of his opinion. But I really think that's what it should come down to. And if she allows Dr. Crosby, if she doesn't allow Rentschler at that point, then again, I think our antenna needs to go up of how unfair this is. But from where I'm sitting, she has already made this decision. Again, this is from Crosby's report. I was asked to examine the evidence in this case, including images, reports, and the involved dog itself, and determine, if possible, the potential source and nature of the defects documented on the right arm of the decedent John O'Keefe. I was particularly asked if I could determine to a scientific degree of certainty whether those defects were consistent with a dog bite or other animal bite. So this is an interesting set of words to me, right? To a scientific degree of certainty or a degree of medical certainty. A scientific what are we asking for? Scientific certainty or medical certainty when it comes to this? Accident reconstruction, clearly scientific. Treatment, clearly medical certainty. Was this treatment necessary? I have asked this question a lot of times using the Daubert standard. And every time, because we have to prove causation, right? We have to prove in every one of whether it's a death case, a truck accident case, car accident case, whatever it is, we have to prove what caused our client's death or what caused our client's injuries. And when we ask, I will just tell you, every time I've ever done it as well, it's been a medical doctor. Not saying it has to be, but every time I've ever done it, it's been a medical doctor on what caused these injuries. Every time I've ever asked that question, in Florida at least, it is to a reasonable degree of medical certainty or medical probability, depending on the time and what the standard is. I've never asked it to a reasonable degree of scientific certainty. Now, when we do an accident reconstruction, that is the scientific term and not the medical term. DN said medicine is science. Yes, it is, but it is used differently in the law, I will say. So that's just from my perspective, what caused the injuries. I've always asked it in a medical way from a medical doctor, but I do think there can be areas in which somebody else other than a medical doctor may be able to shed some light on it, but I do think the best expert would be a medical doctor. The issue presented to me in this case is isolated to the nature, morphology, and likelihood of association between the defects documented on the right arm of Mr. O'Keefe, and as to whether these defects are consistent with, to a reasonable degree of scientific certainty, a bite by a dog. Particularly, a question is the likelihood of those defects being attributable to a German Shepherd type dog known as Chloe, who resided at the time of this incident at the residence near where Mr. O'Keefe was found, or by any other potential large dog alleged to be in the area. So again, the defense, I think, doesn't have to be boxed in that it was Chloe. So it's even more interesting for them to focus on the fact or try to, again, prove Chloe's innocence in all of this. Interesting. Dr. Crosby attempts to opine that the wounds on the right arm of the decedent cannot be caused by Chloe or any other large dog. Thus, his straw man discussion of treatment of the decedent is a distraction, is very much beside the point, and it fails. So again, he doesn't mention it at all. He doesn't mention treatment. He doesn't say anything about treatment. Nobody asked him about treatment. Yet he only uses that to try and say, I do not need to be a doctor because we are not talking about treatment. Yet Judge Cannone herself has already disagreed with that. Dr. Crosby's venturing well beyond his qualifications and attempting to make the sweeping determination that the wounds on the right arm of the decedent could not have been caused by Chloe or any other large dog is also illuminated by his own proclamations. The name of his consulting group is Canine Aggression, and the vast majority of his experience points to canine behavior. Additionally, Dr. Crosby's purported title, Certified Behavior Consultant, also underscores what is already evident. He does not have the requisite qualification to opine on the medical causation of an injury to a human. Yeah, I got to be honest. Certified Behavioral Consultant does not sound like somebody that should be opining on how injuries occur or what causes an injury. Diva Dawn said, if KR is found not guilty this time, is it possible for her to get reimbursed for any legal fees? Also, Megan Boswell guilt, first degree M here in Tennessee. I did see that. I didn't watch much of that trial, so I don't have much of an opinion on it. So really the only way you can get any costs or fees or lawsuits won is if there was real fraud or prosecutorial misconduct. There would have to be some legal reason. Just because you win a trial as a criminal defendant, you do not get reimbursed any of your costs or legal fees. Unfortunately, I want to say unfortunately because it is a serious financial burden, but also the state's got to be able to prosecute people without being in fear that you're going to have $5 million in fees and costs to have reimbursed because you think a jury got it wrong, or one of your witnesses disappeared, or one of your witnesses didn't do a believable job on the stand and you lose a case you should have won, whatever it may be. We're here as prosecutors to protect the public. We are here to fight for justice, and it doesn't mean we're going to win every case. So if every loss turned into we have to reimburse all the fees and costs, that doesn't work either. Accordingly, because Dr. Crosby is not a medical doctor and thus cannot meet the court's medical causation prerequisite, you notice how he keeps saying the courts, not the state of Massachusetts, not Daubert Lanigan, not the case law and the precedent, but the court. He is using what the court said as the rule of law here in this courtroom, which is smart and can happen, but it is different than having all the precedent on your side. Because I don't see any cases that say you must be a medical doctor to render this opinion. But I do hear Judge Cannone saying it with her own mouth. That it needs to be a medical doctor pronounced on June 18, 2024 during the first trial. Dr. Crosby fails the crucial qualification inquiry as set forth in Rentala. And again, that's a general rule. It doesn't say you have to be a medical doctor, I don't believe. Any testimony from him, thus, must be excluded from the upcoming trial on this basis alone. The court need not reach the other prong, methodology of the Daubert Lanigan inquiry to exclude Dr. Crosby because the failure on the qualification prong alone dooms him. However, if the court proceeds to the methodology prong of the Daubert Lanigan inquiry, the proposed testimony of Dr. Crosby fails at this point as well. This is such a lawyer thing to do. It's like, Judge, we won. We already won. We know we won. But just in case we haven't won, we're going to keep going with this second argument. And I agree. It's exactly what you should do, exactly what I would have done. Neither Crosby in his report nor the Commonwealth elsewhere meet their burden of establishing the acceptance of the methodology employed by Dr. Crosby or the reliability of it, nor can they. The Dr. Russell affidavit provides details regarding the incorrectness, flaws, and other unreliable aspects of the methodology employed by Dr. Crosby, including his application of the methodology. And they cite Dr. Russell's affidavit. Somebody tell me where we're at with likes. Did we hit 1,000 likes yet? If we did, we will also be reading Dr. Russell's affidavit. These include his erroneous wound directionality theories and other aspects of his wound discussions, lack of proper forensic foundation and protocol regarding the photography of the wounds, and failure to properly consider canine DNA-related shortcomings of the Commonwealth and its agents involved in the DNA process. So we're also going to be fair, right? Because when we talked about the Commonwealth's motion to exclude some of the Google experts, we have to be careful not to make sure we say methodology is wrong because his outcome is wrong and his opinion is wrong, therefore they must be struck, because we have to make sure that everybody looking at the way things are done for an expert is, if they do it the right way, but they come up to, they disagree on the outcome, that's just how it is. So we have to make sure that we're not saying just because Dr. Russell thinks Dr. Crosby's wrong means he doesn't have any generally accepted methodology. That's not what it means. All right, we're at 899 likes. So everybody go hit the like button. We still have, 8 pages left of this to get there. The extra jurisdictional cases are those involving human and not dog bite matters, and proffered experts who are either forensic odontologists, practicing dentists, or professors with like credentials. Okay. So talking about other bite cases, and these are human and not dog bite matters, we do have some people that are maybe not medical doctors, because it can happen. Even then, when courts do admit human bite mark evidence on humans, the methodology, the experts in these cases followed those practices recommended by the forensic odontology community, including dental molds and the overlay method, in contrast to Dr. Crosby's self-styled and ad hoc methodology. Okay. It's never good when you're just the only guy doing it. And again, I have gotten experts struck for this exact thing where they're like, I wrote this article, I came up with this, I made up this methodology. Usually that's not good enough, unless it's very well peer-reviewed. Explaining the methodology used by Dr. Johnson, which included taking a set of rubber impressions from the defendant's teeth and using the overlay technique, placing a black and white negative of the defendant's teeth over a color transparency. This case permitted the methodology of Dr. Michael West, a forensic odontologist who made dental casts of 12 suspects and excised the portion of the victim's skin containing the bite marks. At issue in this case is the cause of wounds to the right arm of the decedent, and the undisputed facts here is that Dr. Crosby is not a medical doctor, he's not a forensic odontologist or a veterinarian. So they added some to medical doctor to go with the case law, because not only does he not fit medical doctor, he doesn't fit anything they found in the case law that they've cited here. And he does not appear to have worked with any of these types of professionals or a medical examiner in any aspect of this process. In other jurisdictions, states that do admit bite mark analysis do so under circumstances where the witnesses involved possessed expertise and the requisite qualifications in forensic odontology and dentists, and many of them worked in conjunction with a medical examiner. Moreover, our research did not reveal any Massachusetts or other cases that has admitted testimony or evidence with regard to a dog bite and whether such dog bite inflicted wound on a human using Dr. Crosby's methodology. Crosby does not even allege, let alone establish, that his purported methodology is generally accepted in the relevant medical community. This general acceptance concept is a key prerequisite of the Daubert-Lanigan standard and in the alternative general acceptance precept set forth in Massachusetts common law, noting the importance of the alternative basis of the general acceptance theory in determining the reliability of an expert. As a result, Commonwealth fails on this point as well. The thrust of Dr. Crosby's report appears to be based heavily on odontology matters, even though Dr. Crosby is not a forensic odontologist or veterinarian. That shortcoming aside, for the moment, the scientific community has long questioned the reliability of forensic odontology in a legal context, no matter the qualification of the proponent. Oh, yes, they have. And not just they, right? Stating that forensic odontology evidence has been called into question since the early 1990s. The National Academy of Sciences published a report on the use of forensic science in the courtroom. National Academy of Sciences strengthening forensic science in the United States. The NAS report noted that although some forensic odontologists think that bite marks may demonstrate sufficient detail for positive identification, no scientific studies support this assessment, and no large population studies have been conducted. Even more applicable to Dr. Crosby's report is the fact that the bite marks under the non-ideal conditions have little published data, and it is unclear if forensic odontologists can identify the origins of these marks under these conditions. He cites some articles there. Dr. Crosby fails to articulate any concern over the potential error rate or other aspects of the unreliability of his measurements due to these non-ideal conditions. Dr. Russell importantly noted, when a human is attacked by a dog, it is not a static situation. In this situation, the adult's arm moves as he attempts to get away, and his arm would be bending and moving up and down. Additionally, if an adult was wearing clothing, as the decedent was, these measurements likely would be altered even further. The movement changes the nature of the infliction of the wound. Dr. Crosby fails to account for his dynamic environment. An adult moving to get away from an attacking dog, which would affect whether there was a complete bite mark and the measurements of such a bite. This also renders Dr. Crosby's entire methodology inaccurate and unreliable. Even under the most ideal conditions, where there is a complete and clear bite mark analysis is still not sufficiently reliable. Observing the little amount of scientifically valid data that supports the accuracy of bite mark comparisons. In a 2011 peer-reviewed article, noted that because skin easily distorts, it is a poor medium for bite marks. And then they cite some more articles. Dr. Russell also notes the human skin's elasticity, which slides over the muscles in the bone, making it difficult to discern the accuracy of a bite mark. Dr. Crosby fails to discuss this serious concern. Furthermore, the NAS report also establishes that the ability to analyze and interpret the scope and extent of distortion of bite mark patterns on human skin has not been demonstrated. In addition to the absence of the demonstration of his report of general acceptance in the scientific community of the use of forensic odontology and bite mark analysis, Dr. Crosby's report suffers from still other defects. In 2016, the American Board of Forensic Odontology published a bite mark methodology standard and guidelines report. In it, they discuss various methods to document bite site evidence, including taking saliva swabs of the bite site, impressions of the surface of the bite mark, and tissue samples. While Dr. Crosby cannot access any of these samples due to the DNA failures of the Commonwealth, it understands the inaccuracy of it underscores the inaccuracy of his methodology. So really important to see as they're going through this and as they're explaining, they're not just saying Dr. Russell and Dr. Crosby come to two different results, two different opinions at the end. What they're saying is his methodology, first off, they're saying odontology on its own and matching up these bite marks, that's kind of junk science. And we have some very important peer-reviewed articles and studies and groups that say that's basically junk science. But even if it wasn't junk science, if we go to what the odontologists say, they don't agree with Dr. Crosby either. They don't affirm his methodology either. So no matter how you look at it, he fails the methodology prong, and not just because of the result of what his opinion is. Nowhere in Dr. Crosby's report does he account for the absence of tissue or DNA samples from the wound of the decedent. And nowhere in the ABFO bite mark methodology standards and guidelines does it advise using a surrogate, such as a hospital bracelet of unknown origins, to attempt to accurately measure the injuries and wounds on the decedent. This methodology of trying to transfer the measurements and apply them to a human wound is undocumented in his report. Also, in the Dr. Russell affidavit, Dr. Russell highlights the lack of support in the Dr. Crosby report for his methodology of using a hospital band instead of an ABFO ruler in assessing the wound on a human. So this is where we start to talk about how important a bad investigation is. If you don't do things the right way, and yes, Ashley, that's what I was going to mention eventually, is that even Sir Adam Lally said this is basically junk science. And then yet now their expert is trying to get into that exact thing. But when we talk about the specific methodology that they're trying to use here, and the measurements and the swabs and what they should have and what they need to make these opinions, so much of it doesn't exist because of the poor investigation done by law enforcement from the jump. Furthermore, the dog Chloe, examined by Dr. Crosby's report, would have bit the decedent on January 29, 22. Inexplicably, the Commonwealth waited almost 3 years to analyze and measure the dog's teeth in January of 25. Dr. Crosby fails to address properly the scientific concern that Chloe, having aged almost 3 years, could very well have experienced change to her teeth, jaw, shape of her bite, and other aspects in her detention. Obviously, right? And that's like common sense. Relatedly, it is apparent that the Commonwealth retained Dr. Crosby in early 2024. That's kind of wild. They have an invoice of January 29th, 2024. How about that? But waited till December of 24 to apparently take bite impressions from a dog they claim is Chloe. This apparent strategic waiting boomerangs on the Commonwealth and adds to the unreliability of Dr. Crosby's methodology. So to me, that alone, just because they waited, wouldn't necessarily strike everything, but it would definitely be fodder for cross-examination for the credibility. It's like, you didn't even mention that the dog's 3 years older and things could have very well changed, which renders your measurements pretty much useless. As discussed, Dr. Crosby's methodology and application of methodology in trying to exclude a specific dog, Chloe, or any large dog from being the medical cause of the wound to a person is unreliable, suggesting that using bite marks to identify a specific source as the biter may not be reliable. The NAS report revealed that it has not been scientifically established that one's detention will transfer a unique pattern to human skin. And we don't need to get that gruesome, but the reason is there's a lot of moving parts when you bite somebody's skin, right? It's not like that's why when you bite into, if you've ever had like braces or something done to your teeth and you bite into a mold, I never had braces, but I did have somebody shot my tooth out with a BB gun, not a BB gun, airsoft gun. Anyways, you bite into that mold and you have to sit there and hold it very still for them to get an accurate depiction of your teeth. It's not like you're fighting around and biting somebody while they're moving their arm and it's going to get the same exact impression, obviously. Testimony stating that a particular person made the bite mark would not be allowed in those cases. They're citing some cases that say that. Even the Commonwealth itself appears to have looked with disfavor upon the methodology of Dr. Crosby. June 21st, during testimony of Dr. Russell, Attorney Lally asked Dr. Russell if she was familiar with the 2009 NAS report, though he incorrectly referenced it as the NAS report from 2008. Just a little shot at Lally. Lally himself referred to the forensic odontology section, the examination of bite marks, as not reliable science. Attorney Lally questioned Dr. Russell on the practice of matching the mold of a bite mark to a human wound and noted that unreliability of the method has led to questioning its value in scientific objectivity. Additionally, the Commonwealth must not be allowed to state that support for Dr. Crosby's purported methodology is buried somewhere listed in 6 pages of random references and materials. There, Dr. Crosby disingenuously listed these as reference and materials consulted that may affect my opinions in this case. This attempt to camouflage whether he actually used any reference or material he lists and for which proposition on his long list of permissive use of may is improper. The very purpose of an expert needing to prepare such a list is so the opposing party can know what sources the witnesses has considered and is relying on for the propositions in the report at issue. The fact that his entire report is bereft of one footnote further exacerbates this fundamental and scientific failure of his report and methodology. So you may be thinking he's an uncrossable witness because he hasn't cited any of these articles that are peer-reviewed. But he's also not saying he hasn't looked at anything peer-reviewed, because look at this list of references that he says he may have used. Improper, can't do it. He's got to tell you what he used specifically, and so that you can attack it and you can show it's unreliable or that it actually disagrees with what he's doing. You must know that as a lawyer in order for a fair cross-examination to happen, or even a fair voir dire if they end up having a hearing on this issue. The malbehavior, meaning bad behavior, of Dr. Crosby of listing pages and pages of seemingly endless materials without regard to whether they apply to any of the propositions in his report not only deprives the court of properly performing its gatekeeper function, but also imposes an undue burden on the defense. That is, the defense would be required to read all the listed materials just to try and ferret out which one may be applicable. If we ever get to the defense wanting to wait for impeachment material, that line right there makes me think of a lot of the cases I deal with in dealing with impeachment material. Clearly, Dr. Crosby should have footnoted apt references in the text of his report. He should not be allowed to do a data dump of references and obscure the inquiry for all. This is yet another reason why the Commonwealth fails to meet its burden of proffering a methodology. It fails to proffer a methodology that is generally accepted in the relevant medical community and otherwise fails to proffer methodology that is reliable. In the alternative, should the court not grant the defense's motion on the papers to exclude the testimony of Dr. Crosby based on his lack of qualifications and his unreliable methodology, the defense requests an evidentiary hearing to establish the failure of the Commonwealth to meet its Daubert-Lanigan burden regarding the testimony of Dr. Crosby. So they're saying if we need it, we will do a hearing, and Alessi would be the one doing it, which I think he would do very well there. All right, did we get to 1,000 likes? We were so close. I'm sure we did. Let me know if we didn't, or if we did. I am pulling up Maria Russell's affidavit here right now. I want to get to at least one more of the motions, which I think we will, even with Dr. Russell. Here we go. She is Dr. Russell, and these things are correct and true. I'm a licensed medical doctor and am currently engaged in the practice of medicine. I have approximately 30 years of experience as an emergency medicine physician and as a forensic pathologist. Further information about my education training experience can be found on my CV, which is attached here. And then we gave all this to the court, testified extensively. We know her background. I have read and evaluated the self-styled preliminary report of James Crosby. Dr. Crosby is not qualified to render the opinions and draw the conclusions stated in his report. Also, the methodology he uses to reach the opinions and conclusions in his report is incorrect, flawed, and otherwise unreliable. These two overall deficiencies relate to each other, meaning his lack of qualifications likely contribute to his flawed methodology and conclusions. I would have liked to see the Commonwealth do this to Dr. Russell. Get Crosby to explain what's wrong with Dr. Russell. What are the issues with her qualifications? What are the issues with her methodology, which they never did? This helps a judge be a gatekeeper. Educate the judge so the judge knows how to make the right call. The subject matter of the opinions in his report is the cause of the wounds to the right arm of the decedent. The opinions in this regard are variously stated on pages 1377, 82, 93 of his report. For instance, he states, I was asked to examine the evidence in this case, including images, reports, and the involved dog itself, and determine, if possible, the potential source and nature of the defects documented on the right arm of the decedent, John O'Keefe. I was particularly asked if I could determine to a degree of scientific certainty whether those defects were consistent with the dog bite or other animal bite. I have never heard of one stating wounds to a human as defects. I actually have. I would trust her more than me Trust me, she's been around medicine a lot more, but in legal worlds, I have heard things like that called defects. Nor have I experienced a non-medical doctor acting on his or her own to determine the medical cause of an injury to a person, antemortem or postmortem. Lack of qualification of Dr. Crosby. By the way, just because she's never heard of it doesn't mean it won't be allowed. Lack of qualification of Dr. Crosby. He's not a medical doctor, nor is he a forensic odontologist or a veterinarian. He does not appear to be licensed in any medical or scientific field or to possess any other professional license either. He also does not appear to have taken any nationwide examination for his stated specializations. I'm unfamiliar with the 2 degrees he possesses in veterinary medical science. I have not heard of either in my 30 plus years of practicing medicine, including forensic pathology. He does not specify in his report any requisite education or training he possesses in the forensic examination of humans, including the highly specialized medical topics of wound identification and wound directions in humans. Let's say detections, probably. No, wound direction in humans. He does not state in his report any training in the highly specialized and scrutinized area of forensic pathology. He does not state in his report that he worked with a forensic pathologist or a medical examiner for any matter addressed in his report. He states in his report that the particularly at question is whether the wounds on the right arm of the decedent are caused by a dog named Chloe or any other potentially large dog. But then he strays from that charge and claims that certain wounds on the right arm of the decedent are consistent with an engagement of some sharp or semi-sharp object. He does not state in the report that or any qualification that would allow him to make such a claim. In my experience, only certain medical doctors are qualified to make such a claim. I am one such medical doctor. A little chance for her to pound her chest a bit. Some interesting things here that I got from this. So number one, consistent with the engagement of some sharp or semi-sharp object, could be an animal tooth, right? But what she's saying is, he's supposed to say, was this a dog? The answer is yes or no. He's going to say, no, this wasn't a dog. He shouldn't also be able to then opine that this was from the light or jagged edge of a car or piece of glass. Because while he can argue he has some veterinary or dog expertise, he definitely has no car accident expertise, right? I don't even think he tries to claim that he has some car accident expertise. But just like I said, if he's allowed to say yes or no to a dog, Rentschler from ARCA should be able to say yes or no to a car. I also think there's a way in which Judge Cannone says he can testify to certain things and not others. Like maybe, first off, it would be almost laughable if she lets him get into the measurements and the odontology. But if she does let him get into that, he measured Chloe's mouth. It does not match. On cross-examination, Mr. Jackson, you can go into the fact that the mouth could have changed and how unreliable this science is and et cetera, et cetera. That's fine. That came before our jury last time, not the measurements, but the lack of reliability, potentially scientifically, which Lally brought up with your expert, funny enough. But maybe she'll let him do something like that where he can testify to one small thing that this doesn't match the measurements of Chloe's bite mark. Not that it's not a bite mark at all, or not that it is from a car or whatever. Maybe she lets him do one small part just to give the Commonwealth something. I think that would be a mistake. I don't think he should be able to testify to anything personally, especially with the scrutiny we gave Dr. Russell and what she had to do to get where she's at and to be able to make these opinions. It makes no sense that they would call a guy like Dr. Crosby. They could call a pathologist that works in an ER as well and deals with car accidents and dog bites to say, I compared, this is more likely a dog bite than a car accident. Sorry, other way around. Car accident than dog bite to, beyond a reasonable doubt. I don't know. Lack of reliable methodology of Dr. Crosby. There are numerous errors and other flaws in the methodology and application of the methodology described and utilized by Dr. Crosby in his report, which individually and collectively render his report medically and scientifically unsound and otherwise unreliable. This affidavit is not intended to address all of these flaws, but the ones I do discuss each render his report and especially all the opinions and conclusions in it unsound and otherwise unreliable. From an overall structural perspective, his report is defective scientifically and medically. He does not footnote any source of authority in the text of his report. At the end of his report, he merely lists numerous references and materials that he states may affect his opinion in the case. He also describes his report as preliminary response to your request. Neither of these approaches meet medical or scientific norms for the use he apparently intends for his report. Likewise, he does not provide in the text of his report any citation to any literature source which would show that his methodology or his application of the methodology under the circumstances of this case are in accordance with general acceptance in the medical, or any scientific community. Wound analysis methodology of Dr. Crosby. The subject of wound analysis, including wound directionality in humans, is a highly specialized area of practice of medicine. Many physicians lack sufficient knowledge, training, experience, and skills to engage in this area, which is the subject of substantial training. And many medical textbooks and peer-reviewed articles, I possess the requisite education, knowledge, training, experience, and skills in this area. The methodology and application of methodology by Dr. Crosby concerning the wound analysis of his right arm of the decedent are incorrect. First, he evaluates the decedent and his wounds as if they were subject of a static environment as opposed to the proper dynamic environment that existed when the decedent was being attacked by a large dog. And again, she says that as if it's fact, right? Not allegedly, not probably, not possibly, but when he was attacked by a large dog. He wrongly evaluates a dynamic human body like it was a hard plastic and static mannequin. For instance, he does not account for the movement of the various body parts of the decedent during the attack, such as the substantial flexing of his right arm or the movement of his right shoulder to protect himself that would increase the angle of the elbow and move the wounds closer together. The failure of Dr. Crosby to account for these movements renders wrong and unusable all the wound measurements of his report. So to me, that sounds a little bit like we come to a different opinion, not that his methodology is wrong, that he did it wrong, not that I guess that he did it wrong. I guess that is his methodology is wrong. I'm trying to find ways that maybe some way we can see if this is possible, but I'm not finding much. Dr. Crosby wrongly applied his canine detention measurements to a theoretical static arm, which angle of the elbow crease never moves during a dog attack according to Dr. Crosby's methodology, but remains fixed as it exists in his photographs he has in his report. So here's the problem with letting in something like this. Somebody who just does it wrong or has the wrong methodology, the judge should not allow that to go before the jury. Because we know jurors are usually nice people. They want to think the best of experts. Somebody comes in and we call them an expert and the court calls them an expert and we're like, oh, they must be very smart. We have to take what they say seriously. And when we do that as a jury, if it is junk science or just done wrong, and we can show that demonstrably that this is just done wrong, we just can't let it get in front of a jury. But remains fixed as it exists in the photographs he has in his report. He also does not account for the elasticity and compressibility of human skin, which also is not static. Wound measurements change as a result of dimpling and bunching of human skin. Likewise, there are structures immediately below the skin, such as bone and muscle, that would look different during the dog attack. The static methodology approach by Dr. Crosby is medically unsupportable and incorrect and renders his measurements unreliable. Second, he wrongly bases his opinion or his analysis on individual wounds or individual sets of wounds as opposed to the overall pattern of wounds. Third, the directional arrows he inserts into the picture of the decedent on the page of his report are going in the exact opposite direction of how the wounds were actually inflicted. Because of this error in directionality of the wounds, his measurements and conclusions about the distance between the wounds are incorrect. It is therefore his analysis that suffers from a conflict in orientation. This is another flaw in his methodology. Again, even if he can testify, a lot of this is going to come out as major cuts to his credibility on cross. Fifth, Dr. Crosby does not account for, Fourth, Dr. Crosby's arch analysis methodology is incorrect. He claims that the arch is backwards if the wounds were inflicted by a dog. The direction of the arrows he shows is wrong relative to the arch he proffers. Again, these are failures of Dr. Crosby to account for the dynamic environment during a dog attack, and these failures render his measurements incorrect and unreliable. Fifth, wouldn't it be fun some trials to be like, okay, Dr. Russell, you sit there. Dr. Crosby, you sit there. Why don't you guys discuss what you think happened? And the lawyers don't ask any questions. They discuss it like a debate. Then they sit down. And then we go to the next set of experts and we say, experts, why don't you guys talk? And the jury can figure it out there. Fifth, Dr. Crosby does not account for the partial or incomplete bite scenario that is present in the wounds of the decedent. He wrongly assumes both jaws of the dog would be making compression as opposed to glancing bites against the skin, and less than all the teeth impacting the right arm of the decedent, nor does he account for the effect of the hoodie sweatshirt the decedent was wearing and making and discussing his measurements, conclusions, and opinions. These are yet more defects in his methodology. Photography methodology. Forensic photography requires proper qualification and training. The use and application of forensic photography methodology is highly scrutinized, and for good reason. There is no discussion in the report of Dr. Crosby about who took the photographs or how they were taken. It is obvious that at least one of the photographs is distorted and not a depiction of reality. This is a failure of proper forensic photography methodology. Hey, sounds like other distorted videos. Also, there is no documentation of general acceptance in the medical community of the use of the hospital band Dr. Crosby applied as a substitute for the requisite American Board of Forensic Odontology two-dimensional ruler, which neither the photographer at the hospital nor the medical examiner for the Commonwealth used, as they should have, in photographing the wounds on the right arm of the decedent. DNA analysis methodology. Dr. Crosby attempts to make much about the supposed absence of dog DNA on the clothing of the decedent and how he believes this supports the absence of dog bite. This application of forensic methodology by him is incorrect and unreliable. The Commonwealth did not swab the wounds of the right arm of the decedent for dog or any other DNA, and there is no documentation of proper collection, handling, or chain of custody of the clothing of the decedent or the swabs used in the clothing. The DNA testing protocol for the dog DNA employed by the Commonwealth and relied upon by Dr. Crosby in his report is based on a flawed foundation. As a result, this supported absence of DNA claimed by Dr. Crosby in his report does not reliably support a conclusion that dog DNA was not on any wound of the decedent or his clothing. All right. Whew, let's take a quick second. Man, we're almost at an hour. It's going longer than I thought, but we've got about 25 more minutes. I think we can do one more document. What do you guys think? Reese's mom. Clearly, this guy should not be allowed to testify. So based on the last trial, he'll be allowed to do so. Can the Commonwealth go back and resubmit this with more information? Potentially, but if it's outside the deadline, then the defense can say, Judge, they can't just keep going every time we object to something, they try to fix it. But he said he was a preliminary report. So theoretically, they probably could and get away with it if the judge let them, but they shouldn't be able to. All right, let me see what we have next. All right, we have the motion to compel discovery coming next. All right. Defendant Karen Reed's motion to compel discovery. Okay, she says she's entitled to this discovery. It's her constitutional right. Let's get to what she actually wants here. Defense request number 1. Request for all chain of custody logs, reports. Oh, wait, there's one thing I want to say. Sorry, there was like something that was popping in my head and it kept going away. So the absence of dog DNA. I think the Commonwealth's going to be able to argue that. If this guy is able to testify, he's going to be able to argue that. I think the defense has a lot of arguments, as they do with the red Solo cups and the Stop and Shop bags and everything that wasn't done and swabbed and tested correctly and kept correctly. That's going to all be arguments they're going to be allowed to make on cross to discredit it. But that alone, I don't think is going to be something where the judge is like, oh, I'm definitely going to strike that part of his testimony. I think if he's allowed to testify, that will absolutely be part of his testimony. All right. Defense counsel requests chain of custody logs, reports, evidence logs, and or other documentation regarding how the district attorney's office and or state police came into the possession of each distinct production of video surveillance footage from CPD that has been provided to the defense. Okay. So obviously they've been wanting this. They've been asking for this in different ways. How do we keep getting clips from it? Why is this, why are we getting this piecemeal? Why is it edited? Why are there snippets? Why is it inverted? The problem is the defense can do this. And everybody in the public can say, yeah, they deserve this. You got to give it to them. But if the answer just is what the answer is, we don't know, it purges every 30 or 60 days. Some guy saved it on his iCloud account. We showed you what we have. We have officers to testify that it's an accurate representation of what it shows. It is what it is, Judge. They have everything we have. That's probably going to be the answer they're going to get. I don't think they're going to have some great log of, oh, here's the log we've been missing. And it went to, first it started with Buchanan or whatever his name is. And then it went to Proctor, and then it went to Lank, and then it went to, it's like, I really don't think they're going to get a log like that where it goes from person to person. Per defense counsel's November 8th email, Ms. Reed seeks discovery of all chain of custody logs, reports, evidence logs, other documentation. They have this information will provide the defense counsel with relevant details about when, how, and from whom the Commonwealth obtained all of the CPD surveillance video footage, how it was logged into evidence, and what footage exactly the Commonwealth has in its possession, and how that came to be. These details are relevant and necessary to contextualize the raw CPD surveillance video footage and to assess whether that video footage was subject to tampering. Attorney Brennan indicated via the email on November 25th that he would request these records, but no records responsive to this request have been produced to date. My guess is whatever is produced is not going to be satisfactory to the defense. It's kind of like saying, let's go back in time and maybe not use red Solo cups. Let's go back in time and maybe do this right. That's just my opinion on how that one's going to end. Defense counsel request number 2, an unredacted copy of MSP report number 26. Defense counsel also requested via its November 8, 2024 email to Attorney Brennan, an unredacted copy of MSP's report number 26 associated with the investigation into the death of Sandra Birchmore. So if you remember Sandra Birchmore, the quickest synopsis I can possibly get for it is she was a young teen who basically did some volunteer stuff that they do for young people at the law enforcement agency. And she was taken advantage of by not one, but it seeming multiple officers, one of whom she started with an affair with, who got her pregnant when she threatened to basically tell all. He ended her life. And guess what? It was basically covered up. So they want to know, and a lot of it, so none of the actual officers who I believe who had affairs with Sandra Birchmore were also officers in the Karen Reed case, but a lot of people doing the investigation and doing work on it. There is a lot of crossover. So let's read this, and then we'll kind of talk about why they would want this and how they would be able to use it. It's relevant and must be provided in accordance with Ms. Reed's constitutional and statutory rights. The investigation into the death of Sandra Birchmore has involved many of the material witnesses in Ms. Reed's case, including but not limited to Sergeant Lank, Daniel Whitley, Trooper Dune, Trooper Zach Clark, Colleen Crawford, and Detective Kevin Albert, Lieutenant John Fanning, Trooper Gorino, Lieutenant Brian Tully, Deputy District Attorney Beeland, District Attorney Michael Morrissey. Given the similar allegations of misconduct by state actors in the Birchmore and Reed case, the statements that material witnesses in Ms. Reed's case made in relation to the Birchmore investigation are relevant for impeachment and bear on the credibility of those witnesses in the instant matter. Despite defense counsel's request, the Commonwealth has not yet provided the defense with the MSP report number 26. In fact, Brennan replied on November 25th that because the Sandra Birchmore case now involves a federal investigation, defense counsel should seek redacted information from the U.S. Attorney's Office. The Commonwealth has possession, custody, or control of relevant reports from the Birchmore investigation that include statements by material witnesses in the Karen Reed matter. Many of those statements have since been undermined and discredited, and consequently, they bear on the credibility of those material witnesses and are directly relevant to Ms. Reed's case. The fact that the U.S. Attorney's Office may have redacted information does not absolve the Commonwealth of their obligation to provide mandatory discovery Rule 14. Accordingly, this request remains outstanding. And there's going to be more requests specifically about the Birchmore information. But what can Karen Reed's team do with Sandra Birchmore's case and the, somebody said not a great synopsis. Okay, well, give a better synopsis then. Give a better synopsis if somebody has a better synopsis. Okay. So what they can do with this is not take Sandra Birchmore's case and say, look what happened here with these cops. Cops do what they do and they protect their own and they cover up cases. Okay. So somebody said they wouldn't say an affair. She was abused. Okay. I said she was taken advantage of. Sorry. Okay. It's 2-second synopsis. I knew that was going to happen, but it is what it is. So what can they do to use the Sandra Birchmore information? Because they can't just use the case as a whole to say cops bad there means cops bad here. It has to be specifically with the individuals they listed that have crossover with Birchmore and Reed's case, which are all of the people listed here. So we'll narrow it down to there. Okay. And when we deal with impeachment material, because overall the overarching theme here is impeachment. They are going to want to impeach the cops and the DA's office in Karen Reed's case. So how do they impeach it? With their actions in other cases. So what they can do is they can compare investigation techniques, the methodology used. Do they jump to conclusions? Did they automatically think no cop did anything to Sandra Birchmore? And did they try to prove that theory that they started with on day one? Do we have a similar methodology here where they thought this was Karen Reed hitting somebody with her car from day one and they made sure to pin it on the girl? Is there a similarity there that they can show with emails or text messages or reports? Because that might be a way that they can impeach. Did they not find a lot of potentially damning text messages for cops in Sandra Birchmore's case? Did they fail to do certain things in Karen Reed's case when it comes to electronic data or evidence gathering? If there are similarities between the investigations done by these law enforcement officers or the district attorney's office in both cases, that could become very relevant when Guarino's on the stand or when Lank is on the stand. And they can use what they did, what they screwed up in Sandra Birchmore's case, and say, you guys did the same thing here, didn't you? And you can impeach their work and their methodology and their jumping to conclusions. If they say, no, we never jump to conclusions and we're never wrong when we jump to conclusions, and you can impeach that, that's why the Sandra Birchmore case documents and reports could be incredibly important and could be incredibly useful to the defense. C. Unredacted copy of the public records response relating to all email correspondence and communications associated with Sandra Birchmore. They've asked for this. They produced a redacted version made available to members of the public. Critically, the interest of the public in obtaining and reviewing these communications is less substantial than that of the defense. They're saying we need it as the defense. More important in our case, our client's life is on the line. And again, he said, go get it from the state attorney's office. More Birchmore information. There is one that has a little bit of a difference in it. Okay, here we go. Attorney Brennan diverged from his previous response. So in the other responses, he's like, go ask the U.S. Attorney's Office. He said they should seek the materials on the Birchmore case from the U.S. Attorney, stating instead. So this is what he stated for this document. Let's see what this was. An unredacted copy of all reports, communication, handwritten law enforcement notes, and or other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in this case. So Brennan diverged from his previous response. The defense counsel should seek materials on the Birchmore case from the U.S. Attorney's Office, stating instead that he was not in possession of any of these materials and referencing an ongoing defense Rule 17 motion. That reply is not responsive to the defendant's request. There is no ongoing Rule 17 motion regarding unredacted reports, communication, etc. Moreover, despite Brennan's assertion to the contrary, the Commonwealth is in constructive possession, care, and custody of those records, the reports, communications, handwritten law enforcement notes, and other documents sought concern material law enforcement witnesses in the Reed case. Those witnesses are members of the prosecution team under Massachusetts law by virtue of their participation in the investigation evaluating the Reed case, and thus reports, communication, notes, and other documents are in the constructive possession of the Commonwealth. So what he's saying is, if the cops have it, you have it. That's how it works over there, Mr. Brennan, and he knows because he was a prosecutor. I'm just being facetious there. Additionally, interesting for him to say, I don't have this with B and C. He didn't say I don't have it. He just said, go get it from the feds. Interesting tactic there. Okay. All right. We're getting up against time here. All communications, reports, memorandum, recorded interviews, physical evidence, findings, and or other evidence relating to the internal affairs investigation into Trooper Proctor, including transcripts of the administrative proceedings. So this is incredibly interesting. It's also interesting that we keep hearing we're going to get a final answer and there's a deadline and a final hearing for Proctor, and it keeps getting pushed and pushed and pushed. Do we think it's going to get pushed past the trial? The defense is going to be able to use a ton. And by the way, I've also heard Proctor is still sending some text messages that are not so great, that we may talk about in another video. Brennan has provided the defense counsel with a small number of generic letters about the internal affairs investigation, as well as an internal affairs report, which states simply that Trooper Proctor has been suspended. However, the Commonwealth has yet to provide any underlying reports or documents detailing or relating to the substance of the investigation. On November 25th, 24, Brennan replied to Attorney Little's request by asserting that he is not in possession of these materials, other than the documents he has already shared, and that he doesn't believe the Massachusetts State Police shares internal affairs information because, as he understands it, it's protected under Martin. Contrary to Brennan's suggestion, Martin does not hold directly that internal affairs information is protected and is not an absolute bar on the discovery of such materials. It is true that although police officers generally fall within the definition of persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in the case for purposes of Rule 14, possession, custody, or control analysis. Massachusetts courts have recognized that internal affairs files in particular are not always in the possession, custody, or control of the Commonwealth. But the Supreme Judicial Court has held that if prosecutors has possession or control of the records of an investigation by an internal affairs division of a police department with respect to a particular matter, the prosecution must review that material in response to a Rule 14 motion for the production of exculpatory facts. Accordingly, the Commonwealth has discovery obligation to provide any communication and the documents that relate to internal affairs investigation to Proctor and that are in its possession, custody, or control. Those communications and documents are relevant given Proctor's role as the lead investigator in Miss Reed's case before his suspension. The Commonwealth has not met its obligation to produce this evidence, and thus the defense seeks to compel its production. They request all material relevant communication made between members of law enforcement and witnesses in this case, including but not limited to Yuri Buchanan and Chris Albert, by email, cell phone, from the inception of this case. Yeah, we know what this is from. On August 13th, Stoughton District Court received a police report made by Buchanan regarding the instance of alleged witness intimidation. In the report, which appended a screenshot of a text message between Buchanan and Albert, Sergeant Buchanan describes an incident that took place on July 10th outside Albert's business, D&E Pizza Shop. Sergeant Buchanan states that he was notified by Albert about an incident Albert considered to be threatening in nature. Buchanan noted that the text message communication between himself and Albert, Chris Albert wrote, "Hey, so I just had two women outside my shop taking pictures, which is fine. The one woman lifted her hand and made a gun to her, motion to her head. I watched it have it on video. He said, please email it to me," and wrote, "Do you know who these women are?" Albert said, "No clue. I'll email you," and wrote, "Do you know," sorry. In his report, Buchanan also acknowledged that Chris Albert is one of the Commonwealth's witnesses in the case, directly referencing Commonwealth v. Karen Reed. So let me just tell you, when something like that happens, when Karen Reed's case is specifically referenced like this, it's going to be admissible. Now, will all of the text messages between them be admissible? I think they should. Why is Buchanan corresponding with a witness on a case where he's one of the officers and this is one of the witnesses in the case? But if it's something to do with maybe personal, maybe they hang out, maybe they're friends, still seems like it should be relevant. Still seems like it should be admissible. And there's proof that they text, obviously, because Buchanan attached it to a police report. Yikes. And they're saying the fact that the Commonwealth hasn't turned it over is already in violation of Karen Reed's rights. The other text messages may contain material exculpatory evidence that warrants production. It implies an ongoing line of communication that necessitates the need for all relevant communication via phone and email between Buchanan and Albert since the inception of this case. The informal tone and casual language of the text messages between Buchanan and Albert strongly suggest a pre-existing relationship and coordination. And we know they're going to go through them. They're going to pick out stuff, and it's probably not going to be good. Now, if that's all there is, then Commonwealth shouldn't care. Buchanan shouldn't care. Here you go. They also talk about whether it's a personal phone or a work phone, doesn't matter. It's about the case and they're talking about things like this, and he's referencing Karen Reed literally, it should be discoverable. Regardless of whether these communications are subject to mandatory discovery as statements under this or as containing facts as exculpatory, prosecutors are obliged under Rule 14 to disclose any material relevant evidence within their possession, custody, control, or request. Okay. Here, Ms. Reed expressly requests that all material and relevant communication between them. All right. Next. Provide copies of all notes and correspondence regarding any testing conducted in this case, along with all research materials relied upon by the Commonwealth expert in completing their analysis, regardless of whether the witness will be testifying to the information at trial. So these are even consulting experts. The defense is also seeking copies of any and all testing conducted by experts in this case, along with all research and materials relied upon that the Commonwealth experts in completing their analysis, regardless of whether the witnesses will be testifying of the information at trial. So this depends. I don't know. Different jurisdictions, you do have to turn over notes of non-testifying experts. That might just be consulting. Some jurisdictions you don't. Provide all communication between members of the Norfolk County District Attorney's Office and law enforcement and all experts retained by the Commonwealth in connection with the case, including dates and substance of phone calls, copies of any written correspondence, dates of any strategy meetings, and lists of materials received. Number 9, all written communication, including emails and text messages. I assume if you guys have questions about any of these specifically, you'll throw them in the chat. I'm going to read through them, and then I'm going to see what questions before I go. Like I said, I have about 5 or 10 minutes left. So I'm going to read through the rest of the requests, see if you guys have any questions for them, and I will answer them as best as I can. Reese said, if this guy's allowed to testify and Karen Reed is convicted, could it be grounds for appeal? Absolutely. If they let an expert that they objected to, if the judge lets an expert that the defense objects to in, and they have this serious of an objection, then yes, it could absolutely become an appellate issue. All written communication, including emails and text messages between any member of the Norfolk County District Attorney's Office and law enforcement agent and any expert witnesses the Commonwealth intends to call at this trial. Number 10, a legible copy. The Commonwealth produced a series of text messages which are completely illegible. The defense requests the Commonwealth immediately produce a legible copy of these communications. So what's weird about this one is I feel like that could have been handled in an email. Like, hey, Hank, we can't read this. Can you send me something we can read? And then Hank would respond with something they could read, I would assume. But again, I don't think it's the friendliest of exchanges at this point. I think it started out better than it is now. Conclusion. The requested discovery is relevant within the custody or control of the government or its agents and essential for preparation of an effective defense. Massachusetts has adopted a liberal standard for what is considered relevant evidence. Even if evidence is remotely probative of a fact in controversy, it is relevant. As the Supreme Judicial Court advised in St. Germain, the Commonwealth should liberally disclose all material which is even possibly exculpatory as a prophylactic against reversible error in order to save the court time. Meaning, if Buchanan and Albert are talking about all this stuff and it ends up being exculpatory and they didn't turn it over, that could be reversible error. So just turn over everything now and let us analyze it. Production of the requested evidence will not produce unfair or substantial inconvenience to the Commonwealth as the materials are within its actual and constructive custody or control. Denial of such discovery would violate Ms. Reed's constitutional rights to effective assistance of counsel and to due process under the law as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 5th, 6th, and 14th Amendment of the United States Constitution. All right. So we got through three. Okay. Reed has the 86 Celtics representing her. It's going to be wild, Forensic Gator said. A lot of lawyers. It's a big team. Dividing and conquer is probably the best way for them to handle this. When they go to try the case, I am very interested. Are they going to have all the lawyers there? Are certain lawyers going to handle certain parts of it? Is it just going to be two lawyers? I think you have to be careful with how big of a team you actually have at trial because you all have to be in sync. You all have to be on the same page. You have to have the same theory and playbook. Can Judge Cannone deny Betterow? Theoretically, she could, but she'd have to have a reason to. It's very unusual for Prohawks to be denied. Nina, does the silent/non-action of the feds mean they didn't find anything relevant, or are they waiting how the retrial goes? I don't know the answer, right? But what I would say is if they found something they found deplorable and obvious and a huge injustice and major issues going on, I do think they would have stepped in. It's just my guess. Now, they might be waiting and say, oh, if it's not guilty, no harm, no foul. I think that's horrible, and I don't think they should do that. They shouldn't put her through it. They shouldn't put her through the expense. They shouldn't put the citizens of this jurisdiction through that expense and through all of this. They shouldn't put the victims through all of that and all of this as well, if they know. But if she's found not guilty, maybe they're just going to feel no harm, no foul. Obviously, I don't think that's the case. I think there's been plenty of harm and foul if, in fact, they did find something. But we'll see. We'll see. All right. You guys are the best. I appreciate hanging with me. We went a little overtime today. If you guys want more, here's what I'll say. If you want more, so those were the two most highly requested ones on Twitter/X. The third was the ARCA experts, so I'm definitely going to do that. If you guys have any other ones that you're really interested in, send them to me on Twitter. Tag me in the documents with whatever questions you have. Make sure you go there and do that and send whatever documents they are. I will try to take a look at them. And it seems like you guys want more on these documents. I will continue to break them down either tomorrow or Monday. Maybe we'll do a podcast episode on them. But I appreciate you guys so much for joining me here for an hour and 20 minutes. Please hit that like button. Share with anybody else interested in this case. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.